committee this Wednesday, January 29th. And this morning we'll be looking at H118, and we're going to start with Legislative Council. Thank you for being here, Ben.
Well, thank you, Chair Lalonde. Ben Novogratski from the Onset Legislative Council, and I will be sharing my screen to present H118, which is an act relating to expanding the scope of hate-motivated crimes. So, as you may be able to tell from the statute, or the name of the bill rather, we have a hate crime statute in Vermont. And what this bill proposes to do is to expand one of the bases in which you can prosecute someone for hate crime, to expand it from one who commits, causes to be committed, or attempts to commit any crime and whose conduct is motivated in whole or in part by the victim's actual perceived protected category, to expand it from a single person to those that's of another or a group of particular persons, actual or perceived membership. So what this is trying to get at, and my colleague from the Attorney General's office can probably elaborate a little bit more, is when, and it's really there, is when there's actions or conduct motivated by the hate of a group or of another, rather than a particular individual's person. So you might ask, why does it read a little weird? A group of particular persons. That was drafted in such a way based off of a couple of things. In the intent section preceding 1455 and 1454, there is a reference to protecting a group of particular persons. So it's, and I'll read that portion there, which the legislature finds and declares that it is the right of every person to enjoy the public peace and that sense of security and tranquility afforded by the protection of the law, and that wrongful activities motivated by hatred toward particular classes or groups of persons invade that protection. So that is the first sentence of that statement of purpose in 13 VSA 1454. So using that language, but also that language is present in other statutes that implicate First Amendment issues, and I'll get to that a little bit, which is sort of an adjacent issue here. But in our criminal threatening statute, which you might remember passing a few years ago, there was a lot of discussion about should it be group of persons, and it was decided group of particular persons because that was language drawn from U.S. Supreme Court, Vermont Supreme Court decisions when it comes to free speech. While free speech and violation, the First Amendment is usually a defense to these types of crimes, because how do you deduce someone's intent or perception of a person largely by words or conduct? And so that's one of the ways that you can prove this is through admitting evidence of prior statements. You could even get expert testimony speaking to the person's mental state and why they associate with certain groups and how that can indicate a potential bias or motivation. And so it's for those reasons that this language was chosen, because there are what I would say First Amendment adjacent issues here that can be implicated. And so maybe it's a bit overly cautious to include this, but given the intent of the preceding statute and its presence in other places in the law, it's I think a smart drafting decision to insert this language to prevent against any potential challenges to the constitutionality of the statute. So how does this work in reality? So this serves as an enhancement to the penalty of an underlying violation. So for instance, if someone were to assault someone based off of their perceived association with, say, being a Muslim, then that assault and the penalty associated with that assault would be the underlying crime. And then if you scroll down, what this does is that it takes the penalty associated with that crime and enhances it based off of the hate motivation behind it. So for instance, simple assault is a crime where someone is in prison for not more than 1 year. So you'll see here that there's sort of graduated enhancements. If the underlying crime's penalty is 1 year or less, then the enhancement shall be for not more than 2 years or fine of not more than $2,000 or both. If the penalty for the underlying crime is more than 1 year but less than 5, the enhancement is up to 5 years and fine not more than $10,000. So, for instance, a statute that would fall in that category would be the criminal threatening statute that was passed a few years ago. And then third, another one is that if the crime is for a penalty of 5 years or more, then the court shall consider the motivation of the defendant as a factor in the sentencing. So it doesn't really outline a range. It just says, let's just factor in to the initial sentencing of the underlying crime, this hate motivation. So that's sort of how it works. And this is a brand of hate crime. There are sort of 3 different ways it's approached across the country, and Vermont has chosen it to base it on hate motivation or bias.
So just a question on it. So the prosecution would have to prove beyond a reasonable doubt that was motivated by one of these factors. Is that right?
Yes. And then again, in subsection C, we're talking about protected categories: race, religion, ancestry, color, national origin, sex, age, service in the U.S. Armed Forces, disability as defined under federal law, sexual orientation, gender or identity, and the perceived membership in any such group.
Yes, sir.
Piggybacking off U.S. National Guard, could we include those in law enforcement?
That's a policy decision that you could.
I just don't see why we wouldn't if we're including armed forces and National Guard.
That's the committee's prerogative to include.
I know that was directed towards the chair.
Okay, all right, thanks. Yeah. We'll hear from witnesses on that concept. So folks who are testifying could weigh in on that expansion.
And was this, sorry, Martin, I guess this is a question
Yeah, go
for you specifically. Was this proposed last session and we're just,
No,
this is new?
yeah, this is we did last biennium, we did have an amendment to it. I don't remember exactly what the amendment was. Wasn't it last biennium or was it 2 bienniums ago?
I think it was 2020. I think maybe 3.
Oh.
Yeah.
And was this in response to something specific?
I don't think so.
Okay.
No, I don't think so. There wasn't anything in particular.
Okay.
It's the law has been on the books for a while before I got here. It's just that we modified or we amended it a few years ago. Were you here, Tom, for that?
Yeah, so it was last amended in 21,
Okay, all
but
right.
it's been on the book since 89.
Okay, great. Yeah. Yeah, part of what we did last time was in fact expand the categories. I do recall it expanded to U.S. Armed Forces or the National Guard when we amended it in 21. We could look at what the amendment was, but
And then finally, the bill will go into effect on July 1st. That's currently written.
all right. Yeah.
This may be a question for one of our other witnesses, but I'm just curious for actually how this is utilized, both right now in practice and then if we were to make these changes, especially if we were to broaden it to groups. Is it the sort of thing where the prosecutor would amend the charges as evidence was developed and gathered that they could survive a probable cause challenge to like actually charge somebody with this instead of right at the very beginning where, Yeah,
I mean, I would like for my colleagues at the AG's office their insight, but I think it could happen in a couple of ways. I mean, one, it could be right out of the gate if you had the sufficient evidence to bring it. But a lot of times investigations are ongoing, new evidence is gathered, and so you could amend or file a new charge against the individual sort of after the case had already commenced.
Okay.
Yeah.
Other questions? I don't see any other questions. Thank you, Ben. So we'll have Todd Delos. Did I just That's all right. I just make sure.
It's ready for all manner of other usage. This is straightforward, then it's just, or how do I have to join?
Oh, you have to, yeah, those are important.
If I may have a moment to do this. Just have a couple of images that I think will help you carry this. Now I'm gonna, before I go on the record, how do I join the meeting? So I'm going to send you that Zoom link again to your email.
And you are already on the record, just, yeah. So you
The
know,
records happen.
you haven't identified yourself. Or
That's, I didn't.
Yeah, yeah. Fair enough, fair enough.
Thank you, Nate. Let's see how long.
I got it out of it. What's that? Shake that. I know. I'm just trying to get all of it. Well, I just admired this new Yeti. So it must be nice.
This is all on the record.
It's okay.
Yeah.
Oh, you don't think about property.
How about the roads out there?
I'm okay. I was in the lounge.
Oh, okay. Get back.
My apologies for the delay. I could have joined over there.
You know,
Slowly.
we'll cut you change, we'll cut you a little bit this time, but,
Give it back.
future, you expect that you'll be, you know.
I appreciate the largesse.
Glad I didn't mix that.
Oh, you missed out, Ben, so. You had this walkthrough, but that's okay.
It's just.
You know which one.
You should be able to share your
know which one.
Yeah, thank you.
Thanks. Chocolate. I was chocolate my book.
Okay. Excellent.
Good morning. For the record, Todd Delos, Assistant Attorney General and Director of Policy and Legislative Affairs for Attorney General Charity Clark. We're very supportive of this bill, working in concert with Senator Hashim. Our Civil Rights Unit had flagged an area where we saw a significant challenge in bringing hate crimes enhancements and brought forward this language to attempt to fill what looked like a loophole and a gap in bringing these enhanced penalties on hate-motivated crimes. So I want to start with where Ledge Counsel focused, which is this is an enhancement. And it's really important to remember this is not an actual crime itself. So the underlying crimes oftentimes are unlawful mischief, vandalism, criminal trespass, and the like, where individuals are committing a crime, generally speaking, for the purpose of making some kind of attack on an individual who's a member of a protected class. And I would say that's generally what they are, but of course we see much more severe, significant, and concerning instances as well, where it's a real hate-motivated crime that results in bodily harm and otherwise. And I know this committee is very used to these topics, but I do just want to note there's some triggering images that I will bring up, potentially triggering, and any sort of examples I use, I just want to be really clear, are just examples. They're not intended in any way to focus on a particular group or otherwise, but really meant to help illustrate the point. So as Ledge Counsel pointed out, actually the section before the area of the statute that is proposed to be amended is the statement of purpose. And I actually focus on the second piece of that opening sentence, because really at the end of the day, what this amendment would do is carry out the purpose of the original statute, namely that it is about protecting particular classes and groups of persons. As the language currently sits, it's just individuals. It's really helpful, I think, to focus on why this matters and what challenges we're trying to really address. And at the end of the day, and I think the state's attorneys will be most helpful in really talking about how this, where the rubber meets the road. We do some hate crimes enhancements in some of the cases we bring, but it's much more frequent, potentially frequent, with state's attorneys who really carry the bulk of the criminal docket in the state, more than me. So, for example, from Brattleboro, a swastika painted on a public piece of property. what would appear to most of us as a very clear hate motivated crime, right? If I spray painted a smiley face on this same gazebo, I might still be prosecuted for criminal mischief. But it is unlikely there would be a hate motivated enhancement to that prosecution. A swastika suggests a hate motivation. But the town of Brattleboro, which owns this piece of property, is not a member of a protected class. So the victim is not a member of a particular group. And that's where the problem lies. It's the same if someone goes to South Burlington High School and tears down the Black Lives Matter flag. The school itself is not a member of the class. But it would appear that the motivation for the act, it goes beyond simple criminal mischief, trespass, or property crime damage, but actually it's hate motivated. Similarly, another instance in Brattleboro, and these are all within, it's just where we pulled the images. We'll spread it out here. Also Orange County in Royalton, and there's actually an image, right? Somebody had spray painted in the street. That's a public right of way, and I think this is a state right of way. So again, the victim here under the law is the state. In that construct under the current law, there can be no hate crimes enhancement. And I think as a policy statement, the goal really and what the Attorney General supports is expanding the ability to increase these crimes and ideally deter this behavior. And finally, Chittenden County, just to share it, which I don't mean to be flip about it. It is a real issue that is going on throughout the state. All of these crimes occurred within the last 5 years. Well, actually, this next one, no, this is 2019. The next one I want to flag is another interesting twist. And I've blacked out the offensive language here. But this is on the doorway of someone's apartment. So the resident was a member of the Jewish faith. And the individual attacked their doorway, defaced their doorway, used slurs and offensive imagery. But the landlord of the building was not Jewish. So the victim of the property crime, and that's why it's really important. The criminal conduct is one element. This is an enhancement on top of that. Now, I think that, are there any questions on kind of the motivation, our motivation? And
Just that in this last example, I'm sorry.
No, go ahead.
Just that in this last example, you could not have charged the hate crime enhancement on that instance.
Right. The Caledonia State's Attorney, it would have been a much higher burden to somehow demonstrate this language attaching to a landlord. Right. And you're looking at this as a misdemeanor crime.
Yeah.
So one of the goals, and again, it's going to be important to hear from the state's attorney's office. We want to make this as easy as possible under the appropriate circumstances to bring this enhancement.
Okay.
So I can't, I have what it said in I think this is the Gazette, but there could be other facts that could have been on, and we know you more than almost anyone understand the weight of the criminal docket, the incredible pressures on the state's attorneys. So, to the question that was asked earlier about so what does it take to build the case? The real goal here is to keep it as simple as possible, and obviously if a state's attorney finds evidence and information that suggests something broader, certainly that's an opportunity for them to bring an enhancement. We're really in the initial step here looking at, it's a very straightforward, offensive conduct that I think any reasonable person would look at and say, yeah, that's hate motivated. That's what we're trying to clear the brush for, because at the end of the day, we have those actions occurring, but the current language in the statute doesn't allow for the enhancement. So I'm going to stop sharing there. And I want to focus a little bit on the specific language, because we do have a recommended change to the language as presented in H118. From our perspective, and Ledge Counsel did raise, there are some First Amendment adjacent concerns here. When we add that word particular into the statute as it's drafted, the concern is that the burden of proof will actually be not just that it's hate motivated towards the LGBTQIA community, but it has to be a particular LGBTQIA community. And that would seem to create a potentially significant burden for prosecution, because instead of sort of saying they destroyed a pride flag they stole a sign, whatever it may be, they spray painted homophobic slurs on something. It would have to be, it's not a generalized hatred towards this group. It's specific. The prosecutor would then have to investigate which specific element of a protected group would be the victim. The First Amendment concerns here, and First Amendment is always going to be a potential defense to some of these. But again, I want to focus on the fact that the crime itself is unlawful mischief, criminal trespass. This is not about speech in the sense that, again, I could get charged if I spray painted a smiley face or, even potentially graffiti, or other unauthorized public art. If it is a hate crime, because it uses some kind of known hate symbol, that's what we're really looking at addressing. And I think I will also just raise, and part of what motivated our interest in this beyond sort of these instances is we know that in 2017, we saw a major uptick in these kind of public expressions of intolerance. And I use that term, that's a very light phrase for what we saw. We anticipate in the coming months and years, seeing more of that behavior. And we think it's really important, one, to foster productive dialogue, and also to limit what is really hate-motivated criminal behavior. So I can pause there if there are questions.
So with the proposed amendment that you're suggesting, the pictures that we saw and the cases that we saw, if this were passed into law, would most of those cases be able to legitimately get the enhancement? I guess I'm trying to figure it
Yeah,
out.
with your artful phrasing, yes.
Okay.
I couldn't guarantee that the charge would be brought, the facts would matter, and then obviously it's a determination in the sentencing phase. But yes, the goal is to bring those kinds of cases.
Okay, so it would remedy those kinds of exclusion.
Okay.
Yes, and I might have missed it. So I hear the concern of the word particular.
Mhm.
I didn't hear if there was a
Alternative.
yeah.
I think striking it
I just getting rid of it.
can work.
So just a group of persons.
I think at the risk of drafting on the record, and certainly more than happy to talk to Ledge Counsel, I think there are other, hearing, Ben's assessment of it, I think there might be some other ways to meet both by just moving the word particular in front of the word group.
That's fine. We don't need to go through it. I just heard you say that you had an amendment, and so I didn't know if you had exact language already.
It's just striking that.
Okay, great.
From the two instances, I think it's just in there.
Okay.
So other questions? I guess I have a level question. It's kind of goes a little bit to law enforcement, whether to add that or whether to add others. And it's like trying to figure out, I mean, any one of these kind of crimes, there's probably some ill feeling, if not hate, involved. So just as another example, somebody could spray paint on a legislator's garage door, for instance. Happened actually to me, but and I wouldn't think that person, if they were ever caught, they maybe it was hate towards all the legislators because we weren't dealing with the homelessness. That's what motivated this particular mischief. But it's like I'm uncomfortable with an enhancement in that instance, just using the legislator as one. And I'm a little concerned, it's like, where do we draw the line? And this is what, we have is the line drawing on this. And is law enforcement that different? I mean, as a public official like that. So Tom, you want to weigh in on that?
I think everybody that I arrest, I would be able to charge with a hate crime then.
Right.
Can you?
Well, they utter things at us and,
Oh, yes.
when things happen and we are supposed to be immune to that type of banter and behavior. We might use it in an affidavit quote some of it or whatever to show the, the particular anger that the person had, but we would literally come up all of it. Now, if I wasn't working and I came out and saw my car had been spray painted with something referring to me as, bad cop, that would be different, but when we're working down.
Yeah, I mean, yeah, that's just criminal mischief, definitely. But where do we draw the line? I use the legislator as, well, why can't we include legislators? Why can't we include doctors? Why don't we, there's any number of people that people have strong feelings against and could commit a crime against them. And so, Ben, do you want to weigh in on that?
But just to give some context about what other classifications are that other states have out there. So traditionally, it's, race, color, national origin, and religion. Some states don't include color as they may be considered the same characteristics as race. Ethnicity is included in some states, in addition to those other characteristics. And then other sort of less, I think, obvious protected classes, if you will, would be ancestry, creed, age, disability, political affiliation. We have sex or gender and sexual orientation. Others could include unique personal appearance characteristics, family responsibilities, matriculation, membership in an organization, involvement in civil rights or human rights activities, and service in armed services in the armed forces as we have. So that's an example of what sort of out there in the country, some of which we have adopted in our statutes, others obviously we have not.
Right. Yeah, Tom.
One more thing. I support the bill. I'm just seeing something where coming up, and it's definitely going to be First Amendment related, like your swastika on the bandstand. Yeah, it implies something when they say they do it, but I mean, it's victim of that would be society and not any one person. It would of that collective group. I mean, there's not a victim. Now, if I put it on someone of a targeted persuasion on their vehicle, house, to me, then your victim is that person in particular or the family. Well,
Yeah, I would think that,
or are we just trying to target the behavior in general? If they committed a crime and it's race related, are we going to blend the two all the time?
so I guess I would ask, Todd, is that situation out with the bandstand? If that were the case, would there still have to be some proof that there was somebody of Jewish ancestry that actually observed it and actually was impacted by that? Because I see that as one thing, but generally it was put there and actually nobody saw it except maybe in the news, which maybe that's enough.
So I guess the question there is, under the existing statute, as it existed at the time of that behavior, there would be it wouldn't have mattered because the actual victim of the crime, if the crime is trespass or unlawful mischief or vandalism, State's Attorney Shriver could have brought that charge, but not enhanced it because, again, it's public property. So the actual victim of the crime is the town of Brattleboro. Under this language, I think, and to Representative Oliver's point, I think you would have it be more broad and you would say this is a crime against, you would probably have to have, I wouldn't opine on exactly the level of proof that states would bring. Is it enough? Because a swastika, I think as we also know, does have other meanings in other cultures. So you might need to tie that one. But if it was, for instance, the spray paint on the road in Royalton, Bethel, that's a very direct, historically understood racial epithet towards African Americans in this country. And I think that might be enough because it is essentially a hate motivated crime. The crime, again, is the vandalism of the roadway, and it's motivated to spray paint this word. I think it would be challenging to say, and this is our concern with the word particular where it sits, to say it's got to be, specifically the NAACP of Rutland. right? Because again, we want to make it easier for state's attorneys to bring those charges.
The key is the motivation behind the crime. The motivation is to harm a group of persons. And the question is not whether it actually has caused that harm. And that's kind of the way it is right now as well, current law. It's motivation against a particular victim. That doesn't mean that the victim actually was harmed. I mean, by that component of it. They're probably harmed by the pain on the door or whatever, but.
Right, but again, the crime is against the property owner in all of these
Right.
circumstances. And that's what's challenging, is the victim is defined as,
Yeah, go ahead, Paul.
So I'm wondering if it stays very broad to any group of people. It could be, somebody could do a slur about Klansmen and have Klansmen come in and feel, right, so I just worry about not having any boundaries.
yeah, absolutely. Well, you're probably there.
Well, the boundary is the list of protected classes. So, you know,
The current list that Vermont, so
yes.
Martin's example of legislator would not fall,
It's
okay,
not covered.
okay, so I wasn't hearing anyone saying legislator isn't on the list, so then I was thinking we were opening it up.
Yeah, no, I was just using it as an example of danger of expanding the list too much. That's.
Okay,
and
no.
just where do we draw
Okay.
the line on these things up? Ian?
I just want to make sure we have a little bit of testimony on. So we're not just talking about property crimes. This would expand it for all types of crimes.
Absolutely.
So does the AG's office have any thoughts on higher level crimes, violent crimes, where this change would be relevant? Or I just want to make sure we're considering all the ways that this would impact law charges, or how it would impact charging in Vermont.
I have not thought through an applicable scenario, in part because we haven't seen them, but for the most part, the higher level charges, and certainly the high level charges that the Attorney General's office prosecutes, are specific intent individual violent crimes, right?
Yeah.
So there's no question who the victim is. I suppose you could have a circumstance where somebody wanted to act violently towards one individual or a group of individuals, and through their behavior injured a third party who is not a member of any particular class or category. The third party could then, through an assault or otherwise manslaughter, could be the victim. The crime itself was hate motivated. I wouldn't opine onto the challenges of actually prosecuting that enhancement in that circumstance, but again, by and large, those higher level felony order crimes tend to have specific victims.
Just one follow-up. So then this sort of change isn't related at all to the shooting in Burlington, where I think there was like a lot of desire for a hate crime enhancement to be filed, and it wasn't. I was just curious. When I saw this, I thought, oh, maybe that's relevant to this discussion.
Absolutely. And I think it was not part of the internal conversation about, we were really looking at these sort of overt acts of vandalism, largely using these symbols. But I think there's certainly room for conversation to determine how, understanding the challenges that occur in specific cases where a hate crimes enhancement can't be brought.
Yeah.
Or is not chosen to be brought because of, I think, appropriate prosecutorial discretion in most cases. And that's certainly something we'd engage with further conversation on if it feels like there are solutions there.
Ben?
Really good. Now, if I understand your question correctly, I mean, I think it goes to the evidence that the prosecution has. And then in these more serious violent felonies, like an attempted homicide or a homicide, the calculus is different, is that that potential evidence would be a factor in the sentencing of the underlying crime.
Yeah.
Which is a distinction as opposed to the other crimes listed that have different penalties, where you get it kind of stacked on top of the underlying crime's penalty. So with homicide, it would be a factor in the initial sentencing of that crime. And so during the sentencing hearings, you would, and as a refresher, you go through trial, someone's convicted, then typically there's time between the conviction and then the sentencing. Within that time, the parties make their arguments and move whether or not sentencing should be higher or lower based on a number of factors. If there was sufficient evidence to say that there were indications of motivated bias or conduct, that's something that would go into that sentencing memo that's submitted to the judge and factored into that sentencing. So does that get to the question that you were concerned about?
Yeah, so wait, are they not filing like when you have like a violent specific crime, like
That
not
I
filing a
can't speak
hate?
to.
Yeah,
Yeah.
because you're saying basically it just happens in the sentencing anyways. So
For those more,
Yeah.
those, like the most serious crimes.
yeah, okay. That does actually. I guess I'm just trying to. We were only talking about property crime, and I just looking at this, it's going to apply to everything. So
It's not charged.
I'm surprised.
The enhancement, I mean, the statute, you would charge.
Well, it would still be charged.
Yeah.
But just how it plays out in the prosecution is a little bit different because with those less, not to diminish them, but the crimes that don't carry as high a penalty, there is a set range that can be added on to the crimes, the penalties of those underlying crimes. With those more serious crimes, it's a factor in the general sentencing of the underlying.
But you need that's
But you
Fine.
need to charge it.
you need to charge it though to be able to have it considered in the sentencing.
Yes.
You've got to charge it. So that's okay. So
And you would
you'll
still need to prove it.
Right.
You gotta hear.
Yeah.
it'll have to survive all the and to get all the way through to sentencing, you need this enhancement in there to have it considered in sentencing.
Yes.
Okay. Yeah, that does answer my question. Thank you.
Other questions? Do you have any more at this point?
Nothing more, but again, to your larger point about some of those other more publicly known crimes, we're happy to take a look at that as well. I think at the end of the day, some of those prosecutions can be extremely complex, extremely resource intensive. And as you'll note in section, I think it's A3, when it is a higher level felony, 5+ years, the judge just takes the motivation into account. There's not a sort of, we add X number of years on guaranteed. So that also may shift the calculus for a prosecutor. Again, I'm not a prosecutor, I can't speak to that, but may shift the prosecution's calculus in terms of how many more witnesses, how much more evidence, how many more facts do I want a jury to consider to get what may not be actually an added enhancement to this particular crime, especially if it's a significant sentence to begin with.
Yeah.
So do you have any opinion on adding other classes? Law enforcement was brought up in particular.
I think we don't have a direct position unless there are specific categories to raise. And, to actually the example you gave, Chair Lalonde, there are other crimes that can be charged when a public official is a targeted victim. I think there are other, there are certainly enhancements that are available or additional charges that can come when a police officer is assaulted in the course of serving their duties. Same with EMS, same with a lot of other categories. So, I think animus is on the rise in society, or certainly public animus is. And I would just counsel the committee to consider sort of what the historically underrepresented and marginalized groups are and what other tools may exist for additional groups that maybe need to be examined as well to determine, are there other spaces to be supporting law enforcement in addition to how we're supporting other groups.
All right, thank you.
Thank you.
We'll move on to Kim McManus, please. Nice to see you back, Kim.
Hello.
Go see.
Nice to see you all.
We should have some sort of frequent flyer point system.
That would be great, like a little punch card. Yeah.
There you go.
I like it.
Yeah.
Be a million miles.
Yeah.
Excuse me. Good morning. My name is Kim McManus. I'm here on behalf of the Department of State's Attorneys and Sheriffs. We appreciate you asking us to come in today. As a department, we have not fully vetted this around. For our state's attorneys, we will be discussing it at our next executive committee meeting to get more specific input. So for today, we just looked at this bill sort of from a technical standpoint. We don't see, we hear the issue raised by the AGO as far as that word particular. That would be something just to noodle around a little bit more. For us, adding the group of persons, group of particular persons or group of persons, it's an additional tool for the prosecutors. And these cases are so highly fact specific. So I really couldn't get into what cases we think we could potentially capture with that wording. But it is an additional tool and it gives us that option. Whereas if we feel like a particular instance isn't so person specific, that having that group as that or option just gives us literally options. So for that, we do appreciate the addition. We don't necessarily think it would solve all the issues raised today, because again, so fact specific on, and then the big problem, and you all have already tapped into this, is proving the motivation of that individual. That's the big issue. So whether it's for a singular person or a group of persons, that motivation piece is hard. But again, whether the facts can give us that ability to add this as an enhancement, when we're able to, we do.
So we'll expect more after, when is the executive session, executive committee meeting?
I believe not this Friday, next Friday is our next meeting. So we will.
Can you?
Can circulate it. Yes.
So that.
Yeah, it just takes a little time sometimes to gather their thoughts on these, but we will definitely do that. But we don't, on its face, we don't see an issue with it.
And any view as far as expanding the categories at all, including law enforcement?
That is completely a policy decision. That.
Judge Zone all the time.
Then I sound very smart. Thank you. No, I mean, the protected category, looking at other places where we use the term protected category, I think that's a question, right, of what consistency across the board is being used, whether it's meeting a need, that the persons need to be in that protected category. And then that would be, I wouldn't feel comfortable opining on that.
That's it. Sure. Any other questions? All right, thank you so much.
Thank you.
And I'm going to try my best with the pronunciation. I will get it eventually, and I apologize. Is it Angela? Is that close?
Yes.
Oh, right. So if you could join us and identify yourself.
High school?
I did not. See, that's the thing. The only language I've ever tried to learn is Norwegian, and we did have some R's rolling in that language, but still, try my best.
Okay.
Identify yourself for the record and proceed. Thank you for being here.
Thank you. Let me share my screen first. Maybe is it working? Okay.
Excellent.
Oh, nice.
Oh, buenos dias. Thank you for inviting us. My name is Angela Lazo Jimenez. I use she, her, ella pronouns, and I am the policy analyst at the Office of Racial Equity. So this conversation today is particularly important to me because I am Colombian and I am a bisexual woman. So it's important to me, but also to the communities I represent. And I would like to start by sharing a story of a family in Berry. They just bought a house, I guess,
in Berry, and one day one of their neighbors started to threaten them. The guy said that he will burn their house in front of their kids. They vandalized the property. It was very scary. This incident not only affected this family, but also the whole Hispanic and Latino community in Vermont. And the problem with these hate crimes is that the fear is easily spread among everybody. So you were mentioning the Palestinian thing that happened 2 years ago, I guess. That was not considered a hate crime, but the effect of fear was the same. So for the sake of the viewers, I think 2 years ago, 3 Palestinian students were shot in Burlington while speaking Arabic and wearing traditional scarves. So the fear, again, among all the Arabic community in Vermont was remarkable, and nobody should ever experience something like that. So when those kind of things happen, historically marginalized communities across Vermont suddenly start questioning their safety in what they consider home, and that's why we believe this should stop. Sadly, our state has some problems with hate crime. So according to the U.S. Department of Justice, in Vermont, hate crimes have risen from 41 incidents in 2021 to 52 in 2023. And race, ethnicity, and ancestry-based crimes increased from 30 to 36 incidents, as well as the religious-based hate crimes more than doubled from 5 to 13. So we do have a problem regarding this issue. And our office, the Office of Racial Equity, supports this bill because we do believe that it's important to recognize the group impact that hate crimes have, and not only the victim impact that it has. So we appreciate the shift towards a more person-centric terminology in S19 or H118, because again, we do believe that it affects not only one member, but also the whole community. And at the same time, we wanna say that this is only one step in the long line of steps that we need to take in order to prevent those crimes to happen, and in order to support historically excluded and marginalized communities across the state. So otherwise, we think that it's very hard for us to make this state a more welcoming place. And this is very important considering that white supremacy does still exist. And research has shown that, and I'm going to just read this quote, that white supremacy has been noted as a potential driving force in hate and discrimination at disproportionate levels, especially for communities of color. So yeah, again, we appreciate this bill, but at the same time, we need to acknowledge that this is a reality and a more systemic problem. So for systemic problems, we need systemic solutions. That's like what our office believes. And if we don't change this, how can we, because yesterday the governor was addressing us with the budget speech, and he likes to say that we do not need more taxes, but we do need more taxpayers. But again, how can we attract diverse talent to Vermont if people who look and sound like me don't feel safe here? So making Vermont a more welcoming place, it's not only just like the right thing to do, but it's economically good for our state's future. So I wanted to say that. Again, all hate is harmful, and I just want to close by expressing solidarity with all the victims of hate crimes in Vermont that maybe were targeted by or for their race, religion, gender identity, disability, ethnic origin, immigration status, national origin, and so on. So yeah, this is my conclusion. Again, when we make Vermont safer and more inclusive for historically marginalized and excluded communities, we create a better Vermont for everyone. And equity does not only benefit us, people of color, but it benefits everybody. So that's the way I have.
Appreciate that. Thank you. Any questions? So any viewpoint on expansion of the categories, the protected categories? Okay, excellent. All right, well, good. I guess that's it. And thank you very much for testimony. And I see that you did submit the written testimony as well. Appreciate that. So we have that online. So that went a little quicker than I anticipated. We have something scheduled next at 11:30, but we're checking to see if Katie McClin can actually get here at 11 instead, or a little bit earlier, so we can spend maybe a little bit more time. But what that conversation is going to be about is forensic facility, secure residential, just to understand where we are with that. So yeah, Ben.
Looking to kill time, I can brief the committee a little bit on what those First Amendment issues are.
Yes, please join us again. That'd be great. Yeah, thank you. No, that would be an important part of this.
My colleagues joining us.
Could we hear a little bit about like public officials and the like higher burden for when there's
I missed the first part.
but when we're hearing about, because we're talking about expanding potentially, is that what we're talking
Well,
about?
I want, so Zach raised it as an additional entity to have for a protected class. And
Yeah.
It's one of their, open it up. Do we want to expand it at all? Do we want to expand it to that or anything else? Or do we want to keep it as it is? So that's why I just want to have that discussion and get more input on that. That's all. So also just on this, I'm going to try to schedule somebody from Defender General's office on probably to be on Friday. And I've reached out to Chief Burke of law enforcement just to see if they want to weigh in on this as well. So it's like when I hear back from him. All right, over to you again.
All right, well, thank you for having me back up. Ben Novogrodsky from Office of Legislative Counsel. So concerning that specific language choice and whether particulars placed in a different location or removed, obviously is a policy decision. However, it emanates from the concern I recognize from the First Amendment, where you also have in the statute a declaration saying that this isn't meant to infringe on constitutionally protected speech and rights, right? It's sort of a catch-all phrase. It's also present in the criminal threatening statute. So in both of those circumstances, what is not constitutionally protected speech? So an example of that is speech that is considered a true threat. So the true threat doctrine is something that some members of this committee may remember from the criminal threatening bill a couple of years ago. But, excuse me, but a summation of that is essentially, so at the outset, speech generally is protected by the First Amendment. However, there are certain categories of speech that have been deemed to have such little value comparatively that they can be regulated or prohibited. So for instance, the way that can go, or an elaboration of the true threat doctrine is that the general prohibition of that content-based restriction, so the content of someone's speech, what they're actually saying, is not absolute. The U.S. Supreme Court and also the Vermont Supreme Court has identified that within those well-defined classes of expression that carry so little value that can be prohibited, true threats are one of those. And true threats encompass statements where the speaker means to communicate a serious expression of an intent to commit an unlawful act of violence to a particular individual or group of individuals. It's been explained that the speaker need not actually intend to carry out the threat because the prohibition on true threats protects individuals from the fear of violence and the disruption that fear engenders. So that's sort of in line with the testimony from my colleague at the Office of Racial Equity. It's that sort of community-based fear, right? So that's the real harm that these true threats present. And in addition to the possibility of protecting people from the possibility that that threat of violence will occur. Intimidation, in sort of that constitutionally prescribable sense, is one of those true threats. Where a speaker directs a threat to a person or group of persons with the intent of placing the victim in fear of bodily harm or death. So what would that look like in reality? So that could be a lot of the examples that Attorney Delos presented would probably fall under the definition of a true threat, especially when you have a swastika on a Jewish family's door or an upside down red triangle on a Jewish family's door. Those are incidents that clearly indicate what a true threat is. I mean, specifically, while a Nazi swastika might have other meanings in different cultures, depending on the evidence that's gathered. And that's why the First Amendment concerns are so important, because it's about what that person said or may have done at the time, or their associations at the time that that act was committed. So who do they associate with? Is this just sort of a one-off incident that was maybe more to do over a neighborly dispute and got a little out of hand? Maybe. Or is this someone that's a member of an anti-Jewish hate group, and that evidence has been gathered online, and then he or she has made statements online espousing those beliefs? So those are the type of evidence that can be used to say, well, this really was a true threat, because what that person may do if a charge is brought against them and say, well, that's my free speech. You may not like it, because viewpoint discrimination is not allowed in this country, meaning that you can't pick and choose. Everybody has a right to speech, no matter how unsavory it is. But it's when that speech crosses that threshold to the potential of violence or intimidation, is where really the line is drawn. So to put that language in, or at least to be cognizant of the policy, of your policy choice as you debate whether to put that language, it's to hedge against those First Amendment defenses, to say, well, this was really protected speech, and therefore you can't use that evidence against me to prove motivation. So
which language in particular, the new language, or which language in particular do we have?
well, it's that particular term.
Yeah.
Um,
Particular.
right, because that comes from the case law. It comes from other statutes in our.
Do you think we need that term?
I would.
Term.
I think what it would do is it would hedge against any potential challenge to bringing a hate crime statute based on the facts and circumstances of the case, specifically ones that implicate First Amendment rights. Because as Attorney Delos said, it's not always words and First Amendment things. Like, you know, there are other ways that hate can be exhibited, but to hedge, and it would be a policy choice to whether to hedge against those potential challenges to these charges being brought or not. So it's really how much risk and opportunity does the committee, is the committee comfortable with?
So, okay. So just to explore this a little bit more. So somebody marching down the street with swastikas and such, who they have a permit and everything, that's protected by First Amendment. If it crosses over to there being a threat or turns into a riot or whatever, such as happened in Charlottesville, that probably isn't protected by First Amendment. But so this is a little bit different. So somebody paints the swastika on a public surface, so I don't see how that's a true threat, but it's like tied to, I mean, how's that different as far as a true threat from the marching down the street with swastikas? I mean, there's a crime, there's a separate crime now, just defacing this. But I don't see that.
Because there's more of a kind of general impact in that former example of sort of a march down the street, as opposed to a more targeting of a particular individual or group of individuals. So for instance, there's, this is a case out of New Hampshire, actually, that evidence was sufficient to show that the defendant was substantially motivated to commit criminal threatening because of hostility towards Judaism, and that he perceived that victims were Jewish, so as to support the imposition of enhanced sentences under the hate crime statute, because the defendant told one victim that not enough Jews had been killed during World War II and called her a gypsy Jew, and defendant told the other victim that he was going to kill both of you Jews. So it was directed at a particular individual or it seems like more than one individual, so a small group. So it really has to be directed, and again, that's what Attorney Delos was getting at. The difficulty under the current statute is the victim in that apartment building, unfortunately, is not the family that lives in that apartment, it's the owner of the building. And so what this would potentially do is that maybe the perpetrator perceived the owner of the building to be Jewish, and that's why he did it, or vice versa. And therefore, this expansion would at least provide a basis to bring a charge in that situation, depending on the evidence.
I think Ian had a question. Yeah, go ahead.
Yeah, sorry about that. So we'll keep using poor Brattleboro's grandstand. So the march down the street with the permit is general. The grandstand is a public, it's a town-owned property. How does the change in the law that we're proposing capture that?
I'm not sure it would.
Okay. If we took the particular out, would it? And you're saying that it also could be raised at First Amendment challenge?
Potentially.
Yeah.
I mean, again, it's really hard to speculate because all of these are so fact specific. But without knowing more, I mean, maybe there were other, maybe with the grandstand, maybe the perpetrator thought it was built by someone who's Jewish.
Yeah.
So potentially maybe that's it.
Yeah.
But even group of persons generally, it's so evidence dependent, that while it's hard to opine on, but I'm not sure even the removal in that case would achieve the goal.
Yeah.
I think what it would do though, is that if you did go forward with a case, is potentially open up a greater opportunity for the defense to plead a First Amendment issue.
So I think I'm starting to understand them. Yeah. So the particular provides us more defense to the First Amendment challenge.
Mhm.
Either way, it's going to be so fact dependent on the specific case, and it's going to need to be attached in some way to a group. And you might as well make the law more defensible if we're trying to provide more opportunities for prosecutors to utilize it, especially on the lower level crimes.
I think that's a way to capture the policy decision behind it.
Yeah, and I'm not sorry. I guess that's more of my own. Yeah. Okay.
And I would just like to say too that I don't think it's necessary that it would have to get as specific that, say, the NAACP of Windsor County was the particular victim. I think it would be enough if you did something that was racist and it was posted on the NAACP's or headquarters. That would be enough. So I don't think it needs to that level of granularity that it has to be, something directed specifically towards and mentioning the NAACP. More general racist remarks or conduct would fit that bill, but it would have to be something that would maybe be painted on the headquarters.
Yeah.
As opposed to mentioning it per se, if that makes sense, that distinction.
So how deep do we want to dive into the First Amendment stuff on this? Because we could dive a little deeper if we want, because we happen to have an expert on this. I trust your advice definitely, but President Smola of the Vermont Law and Graduate School is a First Amendment scholar. Could be interesting if we want to see if he's available just to kind of dig deeper or.
Yeah, and that's your prerogative. I would just qualify my focus on the First Amendment that it's not the only defense that can be posed. It's a common one, I would say, because how else are you going to show someone's intent other than their words and actions a lot of the time? So I would say that's within your prerogative.
Yeah, it just might be nice that having this as a vehicle to get him in to talk about First Amendment, and maybe there's some other issues that we should be aware of.
It might be interesting to hear if the ACLU has an issue.
Well, there's ACLU, I suppose.
I mean,
I have the Defender General's office that we'll reach out to.
But they're the ones who would.
That's true.
Yeah.
So we'll try to have some more testimony probably on Friday because the Friday is open right now, because things that were gonna happen Friday are probably not gonna happen Friday.
Good thing we don't have the agenda on the door.
because we have to keep on changing it.
It's-
Um,
at least that page.
okay. Any other questions for Ben at this point? Yeah.
Sorry, one other.
Oh,
Sorry, I'm done with questions.
Well, I just think if we're gonna talk about expanding the definition, for protected, like, can you speak to, like, I'm thinking about the civil context for a public official and
So
the
there is
higher.
a, there is
higher
a
standard.
civil action attached to this.
There's civil action, so yeah, so for public officials, you have higher standard, like actual malice, if you're like filing defamation or something like that. Because really important for First Amendment free speech to protect people's opportunity to criticize people who are holding
Mhm.
public service, right? So like in this context, if we were trying to expand it to law enforcement or legislators or,
just like clearly public official.
Well-
Yeah.
you don't think law enforcement is?
Yeah, I'd be curious of what kind.
I guess that's my,
If law enforcement would be included in the public official definition,
yeah.
I'd have to check. Because that's actually a defined term in
Okay.
statute.
Included in what?
If a law enforcement officer would be included in the term public official. But
It's conflating two different things. It's a definition.
Yeah.
yeah, there's,
We'll get the definition,
but you
right?
could also
That's the
read,
point is being
you
conflated.
could also redefine it, because that happens in statute. But for instance, I think like legislative staff is considered a public official, but I don't think, but I'm going to qualify this because I don't recall. I don't think law enforcement is, but I will get the definition for you. It's in the election statutes actually, and it's cross-referenced in,
A sheriff would be, because they're a elected position.
right.
Police chief.
Maybe, I don't know. I'd have to check the definition. Which maybe I can do right now.
My thought is not really a question.
Yeah.
To me, this,
You've opened it
statute
to,
is- Huh?
I'm sorry, we've opened kind of into discussion, so we should open it up. Yeah.
This bill is directed more towards something, you're born into or inherited or whatever. I made a conscious decision to become a police officer, knowing somebody's not gonna like me at times. And the same thing as a legislator, someone's not gonna like me at times.
Never.
But well, it happens a lot. But, you know, where this is something to protect people who had no choice or have very limited choice based on belief or whatever. It's different.
Yeah.
To me.
But what
Makes
about
sense.
services?
Yeah, I mean, it's interesting. Armed Forces and National Guard, which was recently added, is kind of an outlier in that list. Question is whether we want to continue to expand that outlier, and I want to hear from people.
It goes back to what I was mentioning before, though. I'm assuming that when they're at work and they're on base or something, they are protected generally from any kind of stuff. But when they're outside or they're home, it's similar to my situation. You know, it's different, but I wasn't born into it, you know, so it's.
Yeah.
Serious because we're not, you know, you're messing with somebody's belief, not a.
Yeah.
Yeah, so I mean, it is different than the others in here, but again, the question, but we'll try to hear from law enforcement, we'll try to hear from some other folks. Defender General, ACLU, maybe I'll reach out to Rodney Smola if we want to really get into discussions of First Amendment and hate, because that's,
So
How many weeks do we have?
well, I mean, it'd have to be the Friday, I suppose, it's Friday, because I don't think we're gonna have time. We have 5 weeks after. that. So,
That's amazing.
all right.
So just for context, so public servant is defined. Our public employee means a classified employee within the legislative, executive, or judicial branch of the state or any of its political subdivisions, and any employee within a county or local government, and any of the counties or local government's political subdivision. So under that definition, law enforcement officers would be covered because they're employees of either the state with VSP or a local municipality.
What's the site for that again?
That would be 13 VSA 1702, the criminal threatening statute.
All right. Anything else at the moment? Otherwise, we have a free hour to get other things done because our next thing's not till 11:15. That's when Katie McQuinn will be here. So I'll try to not have this ever happen again where we have a free hour. We'll go off live. We'll adjourn until 1 o'clock. No, I'm